Welcome to our deep dive on the unspoken costs of immigration defense. Today we'll explore why legal fees and removal proceedings can spiral, how staged billing works, why strategy shifts lead to price jumps, and concrete steps you can take to control costs. We will move methodically from what to expect at each stage, to the controversy around fee creep, and finally to a practical client action plan. Stay with me through the end for a quick recap and resources, and we'll also test your knowledge with brief quizzes along the way. Let's begin by setting the context and the roadmap for this video, and then we'll cover a quick disclosure. In many removal cases, clients start with what seems like a clear, manageable, flat fee. But as the case progresses, complexities appear. New filings, new legal theories, more evidence, and sometimes a different venue. All of these factors can push fees up, and often faster than clients expect. To avoid surprises, you need to understand the stages, anticipate where strategies shift, and actively manage your agreement. Next, I'll walk you through today's agenda so you know exactly what's coming. Here's our path. First, I'll explain the staged nature of removal defense and typical fee quotes. Second, we'll examine why fees jump, including strategy changes, jurisdiction, and unexpected complexity. Third, you'll get a concrete, step-by-step plan to control costs. Fourth, I'll provide practical scripts you can use with your attorney. Fifth, we'll do quick quizzes to check understanding. Finally, I'll summarize key points and share closing thoughts. Now, before we proceed, a brief but important disclaimer. Disclaimer. This video provides general educational information and is not legal advice. Immigration laws and procedures vary by jurisdiction and change frequently. For advice tailored to your situation, consult a qualified immigration attorney licensed in your jurisdiction. Watching this video does not create an attorney-client relationship. With that important note covered, let's move into how staged billing typically works in removal defense. Staged billing breaks the case into phases. First is the motion to reopen, often used to address procedural issues such as lack of notice. Because this stage is evidence-heavy and critical for getting a second chance, fees are commonly substantial, around $6,500 in the scenario we're discussing. If the motion succeeds, the case shifts to a motion to terminate, frequently based on a newly approved underlying petition, such as an I-130. This second stage is sometimes initially quoted at a modest amount, for example $1,500. However, if termination is denied or contested, you may proceed to an individual hearing, which can be far more involved and costly. To visualize, the flowchart shows the initial filing of an MTR, the court's decision point, the transition to an MTT when reopened, and the potential path to appeal or an individual hearing. Now that you've seen the structure, let's examine where and why fees start climbing unexpectedly. This table gives a sense of where work concentrates and how add-ons appear. For the MTR, the workload includes reviewing the file, drafting declarations, and writing a supporting legal memorandum. For the MTT, the attorney may need to draft a termination brief grounded in eligibility via an approved I-130 or related relief. If the case proceeds to an individual hearing, preparation can expand significantly. Exhibits, witness preparation, and more. Common extra costs include translations, mailing, expert consultations, interpreter fees, attorney travel, and additional motions. Next, we will discuss why a seemingly modest second stage quote can become substantially higher midstream. Fee creep often appears when the legal theory changes, moving from a procedural argument like lack of notice to a substantive eligibility argument based on an approved I-130 typically requires more documentation, more evidence, and more nuanced legal argumentation. Jurisdiction changes can also contribute. Transferring a case or filing in a different venue involves additional motions, coordination, and potentially travel. Finally, unexpected complexity arises when a specific court or judge demands a more detailed submission than anticipated, requiring additional hours to draft and organize supporting materials. With the reasons identified, let's visualize how these factors connect. This mind map centers on the fee increase and breaks it into three primary drivers. Under strategy change, shifting from a procedural defect to a substantive eligibility claim introduces more evidence gathering, exhibits, and generally longer briefs. Under jurisdiction and venue, transferring the case or dealing with a distant court adds the need for separate motions and logistical planning. Under unexpected complexity, we see how judge-specific preferences, additional briefing, and tighter deadlines can expand the scope. Now that we've diagnosed the causes, Let's compare common billing models so you can anticipate how costs are calculated. Flat fees provide predictability and can incentivize efficiency, but they often exclude important extras, which should be spelled out in writing. Effective use of flat fees includes staging them by phase and clearly listing inclusions and exclusions. Hourly billing charges you for actual time spent and can be fair when scope is uncertain, but it is less predictable. If going hourly, ask for estimates, caps, or a blended model. Hybrid approaches exist. For example, a flat fee for core work plus hourly for court appearances. Next, let's move into a concrete action plan you can follow when fees suddenly rise mid-case. Here are 5 steps to regain control. First, insist on a written addendum that precisely lists what the increased fee covers and excludes. Second, question the strategy shift by asking why this motion and why this venue are necessary, and whether this is truly the fastest, most cost-effective path. Third, clarify contingent fees by negotiating fixed or capped pricing for the next stage before you agree to the current increase. Fourth, request specific timelines, draft dates, and deliverables so you know what to expect. Fifth, remember your rights. You can seek a second opinion or terminate representation and request your file. Now I'll give you ready-to-send scripts you can adapt. This section offers practical scripts to use immediately. The first email requests a written fee addendum specifying services, exclusions, timeline, and pricing for subsequent stages. The second asks for explanations regarding the strategy shift and venue selection, focusing on speed and cost-effectiveness. The third email requests the client's file to enable a second opinion if trust or affordability is in question. I've also included a sequence diagram to show the flow from requesting an addendum to clarifying terms, to either confirming, negotiating further, or seeking a second opinion. Next, let's reinforce your understanding with a quick quiz. Quiz time. Question: if your attorney doubles the fee for the motion to terminate mid-case, what is your first best move? Options: A. Agree verbally to keep the case moving. B. Demand a detailed written addendum defining scope, inclusions and exclusions, and timelines. C. Pay part now and figure out details later. D. Switch attorneys immediately. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is to demand a detailed written addendum. This ensures that the new price corresponds to a clearly defined scope, with inclusions, exclusions, and timelines, minimizing future misunderstandings. Now let's continue with one more quick question to solidify your grasp of jurisdiction-related costs. Second quiz question: why can a jurisdiction or venue change significantly increase fees? Options: A. Because courts in other cities are always more expensive. B. Because transferring venues often requires separate motions, added logistics, and possible travel time. C. Because the government charges higher filing fees in other states. Because your attorney wants to delay the case. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is that transferring venues often requires separate motions and additional logistics, including potential travel time. These factors increase the workload, and therefore the fees. With that clarified, let's lock in the core principles you should remember. These key takeaways summarize the most important points. Strategy shifts, venue changes, and unexpected complexity often trigger fee increases. Insist on a written addendum before agreeing to any higher fee. Lock in pricing for future stages up front. Critically evaluate the choice of motion and venue. And remember that you can always seek a second opinion or request your file. Next, I'll present a timeline view of a typical removal defense journey, so you can see where decision points commonly arise. This timeline lays out the major events: hiring counsel, filing the MTR, awaiting the court's decision, filing the MTT if reopened, another decision point, and either termination or continuation to an individual hearing. Under each step, typical cost drivers include evidence collection, legal research and drafting, venue motions, and hearing preparation. Seeing these stages in order helps you anticipate both work and costs. Now, let's wrap up with a brief summary. To summarize, staged billing is common in removal defense, but the precise scope must be clear in writing. Expect rising costs when the legal strategy shifts toward evidence-intensive arguments. Changes in venue, add procedural steps and logistics. Your best defense is proactive documentation, asking targeted questions, and obtaining written addenda. Finally, anticipate and negotiate pricing for the next stage before paying for the current one. As we conclude, I'll share a closing message and invite you to engage with the channel. Thank you for watching. If you found value here, please like this video, share it with someone navigating immigration defense, and subscribe for more clear explainers. Tell us in the comments, which stage worries you most, and what scripts or tools would you like next? Your feedback helps shape future content.